at this time we have another exhibit from the return on the subpoena from the Miami News.
This an exhibit on your motion?
Yes, Your Honor. We've not yet had an opportunity to subpoena in the videotapes of what has been running on the news stations this week as far as the publicity of the trial. But I would represent to Your Honor that it's been on every
Well, I assume it has. It's probably been on most thorough situation. I had an occasion to visit the 9th floor, and I think we've sent people to the moon with less equipment than it's up there, but let's go ahead. I don't have any problem.
But I just wanted to have permission, if you would, to allow us to add further exhibits as they arrive. As you know, the press doesn't like to respond to these subpoenas right away, but I think it's very important that you see the...
I think the court can take knowledge of that. I don't have any problem with the necessity of us fixing the exhibits. We have to understand that there's a great deal of interest, and I do understand there's a great deal of interest, and I understand there's a right for them to disseminate, and I would assume that everything we say in the courtroom is disseminated for the purpose of your motion.
Right, Your Honor, and I would like to state at this time that the main thrust of my argument is that we're moving to abate this prosecution. It was expressed by the United States Supreme Court in Nebraska Press Association versus Stewart that another remedy to protect the defendant's right to a fair trial when there has been massive prejudicial pretrial publicity is to continue the prosecution until in order to abate the effects.
Might I ask you a question at this time?
Yes.
How does one determine prejudice? If there is a dissemination of actual occurrence of what is going on in the courtroom, can you tell me how that's prejudicial?
Your Honor, what we're talking about now is trying to get a jury. And we're trying to get a jury that is fair and impartial, and also the standard is a juror who would be indifferent at the time that they are unsworn. And I think you have seen from voir dire from the last 4 days that is not true of these prospective jurors in Dade County, any more so than it was in Leon County.
Can you tell me one scintilla of prejudice voiced by the last lady we had right out of this panel that was so-called talking?
You mean Mrs. Edge?
I don't know her name. What was her name? I guess it is Edge.
Well, Your Honor, I think that you're talking about one out of perhaps 60 jurors.
That means then we go through 60 more and find the other one, doesn't it? I won't interrupt your argument. Go ahead.
Hear my argument here.
Yes, let me hear it.
First of all, I'd like to argue the statistics in Dr. Hesselbart's survey, which are attached.
This court is paying absolutely no significance to that. She told you as defense attorneys that we couldn't sample the people that we had in Tallahassee unless we sampled them all. Now, I can't buy vacillation. If we can't take 113 people and not get a consensus without seeing them all, how are we going to take 750,000 under that type of presentation by her? Her vacillation is, I think, appropriate to the point advanced, and I might as well let you understand what credibility the court places on that survey.
All right, Your Honor, but I just want to say that I believe that if you...
Now, it's in the record and will speak for itself, but this court is of absolute no credibility to this particular survey. I listened with a great deal of interest in Tallahassee about the one she conducted about the community. And then we asked one day, what ratio would it take to sample those people, 132 or whatever we had, so that I could get a consensus? And I'm told that I got to talk to all 132 of them. So that don't make sense to me.
Your Honor, I don't recall that she expressed...
Oh, I do. You asked Mr. Harvey. He and I had quite a bit of discussion on that.
Also remind Your Honor that at the time you changed venue from Leon County, one of the things you did refer to was Dr. Hesselbart's survey. And I also want to point out that she stated, I think what she said was...
I vacillate too. If it's beneficial to what I'm going to do, I'm going to use it. But it ain't beneficial now, seriously.
Okay.
The reason I didn't really talk about vacillation in that sense.
She
The
did
survey
say-
showed to me up there that there was a great deal of community interest. I think I had to refer to that rather than just to the individual jurors.
But I believe that if you look at her sampling technique, that she has used a reliable statistical method, and that the comparison between what she found in the community, both in Dade County and Leon County, in Dade County she found that 93% of the people that she surveyed had heard of Ted Bundy, whereas it was 98% in Leon County. She stated that 21% of the people in Dade County had mentioned the bite mark evidence as opposed to 20% in Leon County. That's found on page 5 of her survey. She stated that here in Dade County, 47% thought it was very likely or likely that Ted Bundy was involved, and 60% thought that it was at least somewhat likely that he was involved in the Cuyahoga incident. Also at page 9, I think the final conclusion is she states that 2/3 held opinions that might interfere with their impartiality as jurors. Over the last several days, first of all, I do want to say that I'm aware that the court has attempted to ensure a fair trial to Mr. Bundy and has taken steps to do that. And the kinds of things that are recommended by the United States Supreme Court and the Florida Supreme Court, this court has utilized, such as admonishment to the jury and cautionary instructions that they are not to listen to or discuss this case or to form any opinions. But I think that it has been shown here during the voir dire process that that kind of cautionary instruction is not prevailing upon the jurors. The very first day we had Mr. Sutter expressing an opinion in the jury room, and Ms. Suarez told us that he had expressed that opinion, and that was after the court's admonition. Now we're getting into some jurors who apparently outside of this courtroom, and I don't know where the record of it would be, state that they were given some sort of admonition not to discuss the case and not to talk about it or form opinions or listen to news media, and yet yesterday we find that Ms. Rosilio says that in fact that was being done, as well as Ms. McGillicott. Is that her name? McGillicott.
The next juror.
The next juror. Okay, so I think that one of the precautionary devices which this court can use has not proved to work in this particular case, and I believe that one bench conference yourself recognized that what are the jurors to talk about, and that sometimes they do talk about the case in spite of the instruction. Also, a change of venue is one of the things that the United States Supreme Court and the Florida Supreme Court has talked about as a tool to protect the defendant's right to a fair trial. And I believe that what we're seeing here is that in this case, that precaution hasn't worked either. Your Honor has allowed extensive voir dire examination concerning the pretrial publicity to see who has been contaminated, who has formed opinions, and yet still we are encountering these problems that it is so pervasive that it has been disseminated to such an extent throughout the community that it is difficult for us to find jurors here. And I would say
Where would
that
you
everyone
suggest we
seat.
go?
Well, Your Honor, that's why
I like Reno, Nevada. Would you like to go there?
No, sir. What I want and what I'm asking for today is that this prosecution be continued until the effects of this publicity have died down.
Don't you know it'll just happen again, Ms. Gill?
Well, Your Honor, at this point, I don't see that there is much choice, because the last alternative or remedy suggested by the courts is that additional preemptory challenges be allowed to the defendant, so he can remove from the jury all of those persons that he suspects, even if they get up there and mouth their assurance that they can set aside what they have heard and read. If the defendant has some belief that these persons can't do that, can't perform that task, if he has any idea that they would not be fair and impartial as they stand between him and the state, then that's the use of the preemptory challenges to ensure his right to a fair trial. And in this case, what I'm saying is there are just so many people that are getting up there. I think right now it's running that about every 6 or 7 are excused for every one that is preliminarily seated. That to ensure the defendant that he has a right to a fair trial, that at this point one of 2 things must be done. He must be allowed additional preemptory challenges, so he can be sure in his mind that all of those persons that sit on that jury are indifferent and impartial, or that this prosecution must be abated for a sufficient period of time so that the news media, the effects of all of this news media will go away. When I wrote this motion, I first entitled it a motion for change of venue. But events since the time that I have written it have suggested to me that maybe Miami is the best that we can get in this case, and I don't know any other place in Florida that we can go, and I think that Reno, Nevada would be a real bad idea, but maybe Maine might be a little better.
Not bad in the summertime.
And I would suggest to Your Honor that Your Honor's measures to ensure the defendant's right to a fair trial have not been equal to the extraordinary zeal of the press to report and disseminate anything and everything, whether it be rumor, innuendo, suspicion, or lie, or whether it be an actual fact or an occurrence that happens in this court, and that the defendant's right to a fair trial is in serious jeopardy, and I ask you to take strong corrective measures to see that it is protected.
Let me hear from the state.
Judge, I can't add much to what the court's already said. I think the record ought to...
Please don't misconstrue my statements to her. I just like to watch her searching mind at work, and she is very capable.
We ought to wake up a little better than I am in the morning, so I'm not going to go as long. But I think the record ought to clearly reflect that this court has taken the Singer case and various cases on venue and turned them every way but inside out to find a reasonable jury in this case, which really the state has expressed several objections to the excuses, and yet I feel like the 34 challenges for cause that the court has exercised has really been very, very lenient, if not to the defense's favor in some fashion. Of course, they have been, according to Singer, certain dicta in Singer. But I think we're premature on the motion. I think at this point we're about halfway there. And for all we know, the next 3 people may give us a jury of 12 that both sides can accept, and that'll be the end of it. So I think at this point we're kind of belaboring a point that doesn't need to be argued.
I let the record reflect the motion for change of venue or in the alternative to abate the prosecution to blunt the effects of pervasive prejudicial pretrial publicity. I like that style. That's why I wanted to read it in the record. I can understand the labor that you had, Ms. Goodrell, trying to make this motion. The actual motion, as the court construes it, is in fact a motion to do what we've been laboring to do for a few days now, and that is to obtain a fair and impartial jury. An item that this court feels very strong about, both for the state and for the defendant. I fail to see the necessity that any action other than continuing as the way we're going is necessary. I'll deny the motions, and I think we can proceed with where we're at. The court has allowed a great deal of latitude in voir dire questioning, and I am satisfied in my mind that to apply generalities is, of course, not the mission of the court. That's one of the factors that I find difficulty with the polls or surveys. This court is clearly of the mind that we can obtain a jury and we can proceed with the proceedings under the posture that they're in. I'll also deny the motion for additional peremptory challenges. I have indicated and will indicate to you that we have additional jurors here. We have barred jurors from the civil side. They're summoned weekly. and we have a new panel coming in both divisions every week. And I'm sure it might be arduous, it might be tedious, it might be long. But I think one thing that you have to have is the patience of Job. And I've read many years trying to find where his patience expired. I think I know, but I don't think we're there yet. I think we can continue the process as we're proceeding, and we'll be able to get a fair and impartial jury. I would deny all the motions. Bring the next juror in.
This way, please. Take that seat right there, sir, and speak up so everybody can hear you.
You may proceed.
Thank you, Judge. Mr. Brown, I'm Dan McKeever with the State Attorney's Office. Just a little more informal situation than we had before with a large group, so if there's anything you want to explain or talk about,